Welcome everyone to Managing Communication Among Schools, Parents, Medical Providers, and the Community. I'd like to introduce you to all of our speakers for this session. Shari Rosato, Director of Pupil Personnel Services at Schalmont Central Schools. Shari is also the co-chair of the Capital District Special Education Task Force. And Alyssa Galea, she is a staff attorney at Disability Rights New York, and Alyssa is also a member of the Lower Hudson Special Education Task Force. I'd also like to thank our closed captioner for being here today. I encourage everyone here to complete the evaluation for today's conference. I'll put a link to it in the chat box, and you will also be receiving a copy of the link via email. I will now pass it off to our presenters to begin.
Thank you very much, Helen. Good morning, everyone. I'm Shari Rosato. Alyssa is with me, Alyssa Galea, and she is going to present her screen now so that you can see the PowerPoint. I just wanted to give a quick intro as to how we got to this place. I am a PPS director for a school district, and Alyssa is an attorney. Many of the presenters and people that are involved in this conference are attorneys for Disability Rights New York and some other agencies and advocates. And when I first started this job, maybe 15 years ago, my very first contact, my first day, wasn't from a parent or a teacher or a student. It was from an attorney. And that's not the way to do things. So I got involved in this group and have really made some great connections with people and have learned a lot. So Alyssa and I today hope to present to you the laws that govern the communication between schools, parents, medical providers, community agencies, and just some tips and tricks on how to do it. We're all people and we all have the best interests of the student in the forefront, or at least we should. So we hope that you'd feel comfortable asking questions in the chat, and we'll stop and address them at any time. So Alyssa's going to start with some of our legal pieces. So I'm going to turn it over to her.
Thanks, Shari. Good morning, everyone. So we'll get started on the first slide, and just a reminder, of course, we're going to be talking about the laws a little bit today, but just for informational purposes. Nothing I'm going to tell you constitutes legal advice or creates an attorney-client relationship or anything like that. If you have specific questions or concerns pertaining to your student or your situation, I encourage you to reach out to your district or council as appropriate. So getting started, we'll talk a little bit this morning about the two main privacy laws that come into play when we're talking about educational information, particularly information exchanged between schools, parents, and third parties, individuals who aren't employed by the district. So the main law is the Family Educational Rights and Privacy Act, called FERPA. And then there's also, to a lesser extent, the Health Insurance Portability and Accountability Act, HIPAA. So FERPA provides parents or students who are 18 or older, or if the student is completed high school and they've moved on to college or trade school or some sort of secondary education, and we'll call those folks eligible students. So FERPA provides certain rights to parents or eligible students related to their educational records, and it covers three areas. So we'll talk about privacy of records, inspection of records, and the amendment of records. But before we do that, it's important to understand what an educational record is. So a record can be in a variety of formats, things that are writing, digital, videotapes, audio tapes, information stored in a database that is directly related to a student and maintained by an educational agency or someone acting on that agency's behalf. Educational records do not include if an individual staff member, for example, has private notes that they use for their own purposes. And it also doesn't include statistical data, because remember, we're talking about individual student records. And I'm not going to get into much about what to do if you have a concern about FERPA. That's a little outside the scope of what we're talking about today, but I'll just note that either the State Education Department or the Family Policy Compliance Office has mechanisms through which you can file a complaint if needed. And the school district should be sending out some sort of annual notice or have a posting about FERPA general information to families, so you can always check there if you have concerns. So when we're talking about the privacy prong of FERPA, the general rule, and I would be surprised if most folks here who have students in school haven't signed one of these releases before. FERPA privacy requires consent from the parent or the eligible student to release a student's educational records to a third party. And like anything else in the law, there are a whole host of exceptions to this. So we've listed them here, school officials with a legitimate educational interest, other schools if the student's transferring, if the school is being audited or going through an evaluation or accreditation issues, financial aid applications, if there's a judicial order or a subpoena or, CPS is involved, the juvenile justice system, family court, things like that. Are all exceptions where consent is not required. Another exclusion that is important to understand is directory information. So that's information about students, their name, address, phone number, where and when they were born, the honors and awards they've received, when they attended the school. That's all directory information that can be released, but the rule is that schools need to provide parents notice about directory information with enough time for the parent to submit a written request that their students' data not be released. And then there's a link, and you'll get the PowerPoint later on, but a link here just to some more general information. And then we'll talk about access to educational records. So the schools need to provide the parent or eligible student with the opportunity to inspect and review their records without unnecessary delay. So no more than 45 days after they receive the request, which absolutely recommend, that request be made in writing, either through an email or a letter to the district. If the parent or the student can't reasonably visit the school to inspect the records, the school needs to provide copies at no cost, but generally they will be able to physically visit the school, and copies, either the parent or student can make them themselves or the school can make them for them, and they're allowed to charge a reasonable fee per page. And another thing that's important to note is the school's not required to create any records that don't already exist. So examples, writing up a summary of all the disciplinary actions that have taken place, or comparing test scores either over time or to other students. If the record doesn't already exist in the student's file, the school doesn't have to produce one for you. So like I said, when making a request, the parent or the eligible student should submit that request in writing with any, type of consent forms that the school requires. And then also just keep in mind that different types of records could be stored in different places. So if you're, it's a good idea to know kind of what you have specifically in mind if you're going to go look at records, and whether, they're academic records or something through the guidance office or the school counselor, knowing what you want to see and making sure that you are taking a look at everything you're interested in. And then FERPA also covers the amendment of records. And so this is an area where sometimes disputes can arise. So if the parent or eligible student believes that a record is misleading or inaccurate, they can submit a written request that the information be changed or removed from the student's file. There's a right to a hearing if the school denies that request. And if the denial is upheld, you can actually place a statement in the student's file that'll accompany the record. So say there's a description of a disciplinary incident, for example, that you think is inaccurate. You go through the process and they say, no, we're keeping this in here as written. If, say, a college application, you get your student's file, they'll still have that disciplinary record, but then it'll also have the letter from you stating that you disagree with it. But this doesn't apply to grades, disciplinary decisions, or opinions of school personnel or other individuals. So if you're like, oh, my student really should have gotten a B or, instead of a C on that test, that's not a FERPA issue. That's something, to take up with the teacher. And then I'm going to talk just for a minute about HIPAA, because I know we hear about HIPAA all the time and it's super kind of confusing as to what it requires and where it applies to. But in the educational context, we're most concerned about HIPAA when we're talking about records from an outside provider coming into school personnel. Because HIPAA protects what's called protective health information, but only by entities that are covered by the law. And so when we're talking, I'm not going to get into the whole list of them, but when we're talking about covered entities, in this case, we should really be thinking about doctors' offices and medical providers. And it's not a release or a specific written consent isn't required in all circumstances when information is going to be shared with the school. For example, if your child's doctor is sharing information directly with the school's physician or nurse about, perhaps a prescription or medication dosage or certain immunization information, a release is not required. And I also included, a link about some more general HIPAA and FERPA information here. But I'd just say, generally, I think it's very helpful if you're a school and you need specific information, or if you're a parent and you want specific information or records to be coming in, have a conversation with, the other folks involved about what information they need, who it's going to come from. It just really helps build trust between different groups and keep people on the same page if you all know what you're looking for. So like I mentioned before, generally in the cases where written consent is required, the school, or if it's a HIPAA release with information coming from a doctor's office, probably has a form already that they'll ask you to sign. And I've seen the whole range. Sometimes the forms are super specific and detailed, and sometimes they're incredibly brief and broad. So we do tell particularly parents, that if a release is super broad and that makes you uncomfortable with the amount of data that could potentially be released, you can always write in and make it more specific, either, specify that it's only information from this time period, only records pertaining to this particular subject. But like I said, again, if I can, the one most helpful piece of advice I think I can say on this is, if you have questions either about what you're signing or what the information is used for, just ask them and have that conversation, before you sign anything, because consent, you can revoke it later, submit something in writing saying, this thing I signed is no longer valid. I revoke my consent. But it's much better to know what you're getting yourself into on the front end before any of this happens. So have a conversation if you're being asked to sign something, or if records are needed, just talk about what's needed and how you're going to get it.
Okay, I think that's my slide, right? So who do we communicate with? There's a lot of individuals and agencies that as a school district we communicate with, and as parents you would want to communicate with as well. Doctors, medical doctors, we get a lot of diagnoses from doctors. We have a lot of folks that have psychologists do evaluations outside of school, non-district psychologists, and not necessarily people that we approve of an independent educational evaluation for. A lot of parents will come in and just have an evaluation that has already been completed and say, here, look, I had this done. Now we have to do these things. So we need to talk to the folks that did that. So we get permission to do that. We do speak to a lot of attorneys. They're people just like we are, and they're there to advocate for their client, and we're there to advocate for the students. So we have a lot more in common than you might initially think. We do speak to the hospitals a lot, especially if our kids go to the emergency room and they're seen. Sometimes they're sent there from school by ambulance if there's a mental health issue, or even if there's a physical issue. Mental health facilities, we have kids that are placed in facilities for a few weeks, a week, a few days. we do need to speak with people in those facilities. Other schools that students have transferred from or are transferring to. Parents, there's a lot of family dynamics, so we are very careful who we have permission to talk to about the student. There's parents and step parents and dad's girlfriend and mom's boyfriend, and there's often a lot of times where people are at odds as to who you can speak to. So we make sure as a district to have everything in writing as to who has custody and who we have permission to talk with about a student. Teachers, not just teachers at our school that know the student, but maybe teachers from a past school experience that the student had that has some insight for us, and the students themselves. A lot of parents, especially for the younger kids, which is understandable, don't want us to talk to their student about things without them being present. So it might be a discipline issue. It might be an issue with a student's IEP. Our older kids, high school age, definitely, we sit down and pull out an IEP and talk with them and say, what do you think about this? And then go and run it by the parent. We always have our students at meetings. When we have a meeting about their program, their plan, we always have our kids there. I'm probably forgetting somebody off that list, but the point is it's a vast amount of people that we communicate with. So it's important to make sure that you have something signed saying that you are allowed to communicate with those folks. I see Susan's question. Do you want me to just jump in and answer it, Helen?
Yeah, definitely.
Yeah, we do have probation that we do talk with, and
Shari, I will, if you do a question from the chat, I would ask that you just announce the question so people who are on the phone. So since I'm already talking, I'll announce the question and then I'll let you answer it. Yeah, it says criminal justice entities. How do they get and share information?
So usually we have a probation officer that works with us at our high school that is assigned to our school district. And we have folks that do the pre-pins, pins diversion kinds of things. They usually have a consent that the parent has signed for them saying that they can speak with us. I always ask if they have consent to talk to me, and they will to either just say yes, and I know the person, so I believe them, or they fax it to me or email it to me or something. But if they are the person or the group that started the initiation of the communication, they will have a consent. If we want to talk to someone in the agencies like that with criminal justice, usually not all the time, but usually the parents are on board with us and they will sign off for us. So I have a bunch of different consents that are specific to special ed, that are specific to discipline. And then there's like a general one saying, hey, my student goes to Schalmont and you can share information with, and we leave a blank and they write it in. So we do try to get consent for everything just to cover our bases. We learned that from all of our friends that are attorneys. So we try to do that as much as possible. All right, I think we can go to the next slide. Perfect. So effective communication. We really want it to be professional and cordial. And I'll use the word friendly. I consider myself a friendly person and I like to talk to people. So I don't have a problem calling a parent and just chatting about the younger brother or sister and trying to build that relationship. It's important for our school districts and all of those other agencies and folks to have good relationships with the parent and with one another. So we really try to keep it professional, cordial, and friendly. Our communication, it goes much more smoothly when it's targeted, when we have a purpose and we're not just calling to fish for information. If I have something specific that I want to know from an outside psychologist that's seeing a student, I will directly ask them. Same thing from an advocate or anyone that I speak with. And it works better if that happens the other way too, rather than someone calling and asking just generic questions. So have a purpose for the communication. I've learned to never assume. I might assume they know what I'm talking about and they hadn't heard about an incident that happened. So I'm always specific and clear in my requests and in questions that I ask. And even if I sound redundant, I might ask something a different way just to make sure that I'm getting the information that I'm really looking for. And I encourage parents to do that too. One of my pet peeves is when it doesn't focus on the student. And a lot of my conversations with some parents, especially when there are split families, that happens a lot, where mom wants to tell me about what happened at dad's house and dad is not on the same page with this outside evaluation that mom is. And I really like to refocus them back on the student. Back in the day before all of our virtual stuff, we used to sit in a room and all meet together. And if the student wasn't with us, then I would always have a picture of the student in the folder. And I would hold the picture up when it got a little dicey and say, remember, we're focused on Joey or Susie or whoever. So we always look to the student, and I don't want to say old, but a veteran superintendent from years ago told me, look to the learner and you can't go wrong. So I always keep that slogan kind of in my mind and keep refocusing on the student, because that's the only reason that we're all communicating, is we want to make sure that we're doing what's best for the student. Communication should be timely. If something needs to get run past the parent, or if you need to schedule something with an outside provider, don't say what's Thursday. Well, I'll get to it Monday or Tuesday. A quick phone call, do it quickly. It should be something like when they call me, I don't want to know about something that happened 3 weeks ago. I want you should have called me 3 weeks ago. I want to know what happens when it happens. So keep it timely and be prepared. Prepare your conversation first. I don't want to sound silly, but sometimes I rehearse. It depends on who I'm calling and who I'm going to speak to. And sometimes I rehearse it in the car that all right, I'm going to talk about this. I'm going to make sure I mention this. I'll start with a hi, how are you doing? I hope you had a great weekend kind of thing. So I try to keep it friendly and just be ready to talk to them. So I'm prepared as to what I'm going to say. And I also included on here that we should always look for common ground. It's really important that we remember that we're all there for the good of the student. And we do have a lot more in common than we think. And that's what I had alluded to earlier about working with a lot of attorneys. Coming into this position 12, 13 years ago, prior to that, I was an elementary principal. I didn't have a lot of reasons to work with attorneys in that role. But as a PPS director, I encountered attorneys a lot more and I learned a lot. And the attorneys and the advocates that I've worked with that I may have been nervous about communicating with in the beginning are my first calls now, because we do have a lot of things in common and we're really just trying to provide the best education for students with disabilities as we can. I think you can go to the next one. Perfect. Okay, so this is a quiz. So true or false. So you're going to have to use your little reaction button. So if you see at the bottom of your screen, it says reactions. You click on that. A thumbs up would mean true, and the oh my goodness face with the big circle mouth, open mouth, would mean false. So first question, number one. The doctor wrote a prescription for an IEP. The school has to honor that. True or false? Oh, Deb's right on it. Diane's right on it. Correct. It's false. We don't have to honor a prescription. And if you are a school district person, you're probably as frustrated as I am when we get literally a prescription pad, like they would write, for, a muscle relaxer, and it says student should have IEP. And that's all they bring in. They go, oh, the doctor said you have to do this now, so you have to do it. We always, and this is a district specific thing, we always meet with the parent and have a CSE meeting when there's a request like that. The school has to consider it, but we don't have to do it. We always listen to the parent and try to get the doctor, if it's a physician or an outside psychologist, to weigh in on that as well. But it's not a have to. We try to be cooperative and collaborative. So we'll look at what the reasons are. And there's a process. And a lot of doctors don't know the process. I don't diagnose kids with, viral infections because that's not my field. So I don't want a doctor telling the school district this student has to have an IEP because that's not their field. We want to collaborate with them. So that's where that building relationships and communication with the providers, the outside providers, comes in very handy. That's very important. Okay. Again, true with the thumbs up and false with the oh my gosh face. Okay. Number 2, the school says my child does not qualify for an IEP. There's nothing more I can do. And these are pretty easy, right? Yeah, it's false. There's a lot more that you can do. And you don't have to jump directly. And this is where I'm going to call on Alyssa to jump in with me. You don't have to jump directly to due process. There's a lot of conversations that can be had. I have often suggested to parents, let me give you the name of a couple of student advocates and you can talk to them. And then we can have a meeting and talk about, what the concerns are. But there's lots more they can do. Right, Alyssa?
Yeah, absolutely. And, when you've been talking about, your relationship and working with attorneys, I think, some cases, right, that I got involved with certainly are something terribly legally wrong has gone bad. We got to fix this. But just as many, if not more, cases are, well, we're not having a trusting relationship between the family and the school right now. We're not on the same page. I'm feeling emotional and unable to listen, or they're feeling stressed and unable to communicate. And so people will come, jump right in, ready to go straight to due process, wanting to file a lawsuit. But really, a lot of the time, if everyone sits down and breaks down, what, like you said, so my child's struggling in school and the school won't give me an IEP. Okay, they're struggling in school. What do you mean by that? Are we having a hard time getting them to go to school? Are they struggling in math classes, reading an area of difficulty? Like being able to come to the table and say, these are the specific, not everything's going wrong and you won't help me. What do I do? Why are you awful? These are the specific things I'm concerned about. These are the specific things I think or their doctor thinks might help. How can we look at making that work?
Let's look at the next one. My child has a diagnosis, so he automatically gets an IEP. False. We have a lot of kids with diagnoses that don't have an IEP. Sometimes it's warranted and sometimes it's not. And that's something that the communication with parents is crucial, because I have a lot of parents that will come in, and so do many of my colleagues that I talk to this about, that will come in and say, well, he's diagnosed, even with a diagnosis that could be as significant as a student with autism. If there's not an educational impact, that student does not necessarily need an IEP or a 504 plan. There may be cases where it is warranted, and there certainly are, but it's not a given. It's not, one does not necessarily equal the other. So I think you're probably figuring out my system. Number 4, the math teacher does not have to use modifications on the IEP that the special education teacher wrote. Also false. The teachers are obligated to follow that IEP. Ideally, I'd like the special education teacher and the math teacher to be writing those accommodations and modifications together. But definitely they do have to follow them. That's a document that is a living, breathing document, and it's something that needs to be used throughout the school environment. Number 5, the school can deny services to my child if they cost too much. I think that's a misperception of a lot of people. They'll say, well, our school just doesn't have the money to pay for that. That's not the reason that it's not a reason that services can be denied. We consider ourselves very creative thinkers in my district, and we try to find a way to provide a service to a student with certain provisions that we already have existing in our district. If that's not possible, we often look to other districts and say, do you have something that might work with this student? Could we cross contract with you? There are times when we've had to put a new teacher or a new assistant or a related service provider in place that we did not have already in the district because a student has moved in. So no school district should be using we don't have any money as an excuse. That's illegal. And Alyssa will tell you that too. They can't do that for your child. That's not allowed. And number 6, my child's doctor can tell the school what accommodations my child needs based on their medical condition. I think somebody put something in the chat about that. And technically the doctor, you're right, technically the doctor can tell them. And I want to hear from the doctor. I want to know, what do you think this child needs in a school environment because of the medical condition? So like, for example, access to air conditioning is one that comes up a lot with students that are unable to regulate their body temperature. Some students that have seizure disorders. We don't put an air conditioner in every single classroom that the student is in, but we give them access to air conditioning. So if they become overheated, which we've trained teachers to check and decide, how to talk to the student, decide if that's really becoming an issue. Some kids can't recognize it. We bring them to an area where it can be air conditioned. We usually air condition the core classes, but maybe not the lunchroom. And then if it's a hot day that day, the student might eat in the office conference room or something. So yes, we do want to hear from the doctors. They can certainly suggest. They can't tell us, but I'm not a doctor. So if a doctor tells me this student really needs this accommodation, otherwise their medical condition will flare up or it will be an issue, I don't want to be responsible for that. I'm certainly going to put that in place as a district as much as I can.
So I think now, if it's all right with you, Shari and Alyssa, I've got a couple questions from the chat that I've been saving. The first one says, do we have to justify request access to the educational records for our student? Do we need to present a reason to request those documents?
No, so the school might ask you, and it's okay for them to ask, but you don't have to come prepared with any explanation beyond, I'd like to see the file.
And we always tell all of our providers that I have all the files here in my office. We house them all here and they're in locked cabinets. So whenever a psychologist comes in and wants to put something in the file or take a look at the file or whatever, they do it in here. They don't take it with them. Anything that's in the file that gets put in the file is also something that the parent should have gotten a copy of. So we don't put anything in here unless it's already gone home to the parent. So I had an occasion where a teacher said, I took these notes when I was talking to the mother and I don't want to lose them, so I'm going to put them in here. And I said, if you put them in there, then you need to send a copy of those notes home. And if they ever request a copy of the file, they get a copy of that. Or if their attorney ever requests a copy of the file, they get a copy of those notes. So we always make sure to give the parent everything that we have. But if anyone ever asks for a copy of the records, we copy the entire file with no questions asked. I think that's how we're supposed to do it. Right, Alyssa?
Yes.
Awesome. The next question we've got is, we are often told that schools do not have to show videos made of students at school unless the district intends to use it as evidence at a disciplinary hearing. This often seems justified by the fact that other students may be in the video, but even when no one else was present, the school still refuses to show the video. What does FERPA say about that circumstance?
So that's a really complicated question. And I will say yes, what we would frequently hear is a concern if there is, say it's a video camera that's focusing on a hallway or a lunchroom, there are probably multiple students who are going to appear in that. And the school does have to balance your right to access your child's educational information with the privacy of all of the other students who are there. I'd say it depends on what your situation. I know, right? That's the always attorney answer. It depends. But it depends on what your situation is and what you're seeking access to. If it's something where there's a disciplinary issue that it's caught on camera, or a bullying incident, if it's something that's going to be certainly used against the student, or sought for evidence at a due process hearing or for a complaint, those are more specific conversations you need to have with a district. And if they're really holding ground against releasing information that is going to be pertinent for an issue, then that I think would be a good time to get an advocate or someone involved to talk about your details more specifically with you.
And we also got another question in the chat as you were talking, Alyssa. It says, can you please repeat if a school can call and speak with the physician without permission from a parent in regards to a prescription they wrote asking for specifics, particularly with a feeding tube? So I think we had talked about that early on in the presentation.
Yeah, so there's an exception in HIPAA for medical personnel direct conversation. So if it was, that's envisioning, right? So with a feeding tube, perhaps, okay, well, how much is supposed to be administered and how often, and like the details of, this is a prescription, this is a dosage, this is how physically this medication is going to be administered. That being said, if you have a student who has medical needs, if they have medication or other prescriptions that are going to be administered during the school day, I think getting a consent and having that on file is a great idea. And making sure if, especially if the student has complex medical needs, that there is an open line of communication between the provider and the school nurse or whoever is going to be in charge of that in the district, so that you can have that ease of direct communication to get questions answered.
Fantastic. Okay, so I'm going to let you guys get back on with your presentation, and I'll keep saving questions just to make sure that you cover all the material that you had planned, and keep the questions coming in the chat. We'll circle back to them in a little bit.
Great.
Okay, so we're gonna elaborate a little more on this, because sometimes, particularly if the relationship is not already the best, we have questions from parents or students about, okay, well, why does the school want to communicate with outside providers? Why are they, getting into my business? Or why are they concerned about private information? And so there are kind of three different general scenarios, I think, that this can be really helpful. So the clarity of information, like we talked about with things like prescriptions before, or even just general recommendations, seeing things like, okay, the doctor will write a note, the student has asthma, so they should not be doing outdoor recess in extreme temperatures. Okay, well, what does that mean? When you're the doctor writing that, you probably have something in mind, but then the teacher who's, in charge of the recess period, you don't want to put that kind of judgment call on them. So the clarity of information to say, okay, this is how we're really going to make this recommendation work, and understand what it is that you're trying to tell us and when this might become an issue.
Sometimes that goes the other way too. We often get recommendations from a doctor, and it's clear that the doctor doesn't understand the situation in the classroom or the school environment. And they didn't come from a classroom, they came from the medical field. So it's important that we do get to speak to them and get that clarity.
Another topic is the consistency of services. So sometimes I've had cases where a student, has counseling on their IEP, and they see their counselor at school every week or every other week. But then, through the family's insurance, they're also seeing an outside provider, and, allowing those individuals the opportunity to communicate and say, hey, we've been working on, this type of approach with the student, and it's going really well. Or we have been really super focused on this issue, and we're making a lot of of progress here so that they can reinforce and keep consistent progress with that student of the types of methods and strategies that they're working on both inside and outside of school. And then also just having an open dialogue like we've been talking about recommendations and progress too. So, I think it's really important. Sometimes things happen at home and, something might have happened in the family that's going to has the student a little dysregulated or upset, or that, it would be helpful for the school to be aware of so they can keep an eye out for that. But then also on the positive too, maybe someone had a real breakthrough in their counseling or an achievement in their at home, or something great happened that the school providers want to know about and want to work with and celebrate with a student too. So being able to keep everyone on the same page about the important stuff can really help with a student as well. All right, and then we'll go into, and I think none of these should be as a surprise to anyone because Shari's already walked us through our pop quiz this morning. But I'm sure she'll appreciate me saying, and I cannot say enough, that when we're talking about an outside provider, we're talking about recommendations. We're not talking about prescriptions, unless of course, the outside provider is your child's doctor who says they need to take, 25 milligrams of this medication at noon. That's a prescription, and the school is, probably not going to have to question that because they want kids to take their medication and be healthy. But rather when outside providers, whether it's your child's medical doctor, their therapist, another service provider that they see, they have information because they see that kid in a different context or in a different setting, and they could provide some really helpful insight, but it's not a demand and it's not something that the school is required to implement. And I'll say in my own experience, I think we've all seen circumstances where parents will go to a doctor and say, write this letter, say, my child so-and-so needs X, Y, and Z. And I think that's really counterproductive because it cuts off that dialogue. And like Shari already explained, it's not something that the school district has to implement, and the doctor or whoever it is might not be super familiar with the school environment. And I've seen parents, almost get backed into a corner. They said, okay, I worked so hard to get my doctor to say my kid needs X. Come to find out that's not something that can be appropriate implemented in their current setting. And now we're talking about, okay, do we need to consider a more restrictive environment or a change in program, and it can all go very wrong. So going off of that, being specific, if you're an outside provider and you're going to make a recommendation to a school, being clear on what that is and how you think it should work, and why you think it's needed is really helpful, but then also not getting into too many details because again, you're not giving a prescription to the school and you don't know what the child's classroom looks like and you don't know how the program works, and you can't, from the outside looking in, say this is specifically what needs to happen, but rather I observed, that this is an issue and that this seems to help or that this could be beneficial. And it's not about who can yell the loudest at each other or write something on the most official looking letterhead. It's who can provide helpful information from different settings so we can put it all together and figure out the most appropriate plan for the student. All right, and then we're going to wrap up this section just by talking briefly about independent educational evaluations because these come up and these are, tend to be a big area. And we're not going to get into how one goes about getting an independent educational evaluation or IEE because that could be a presentation in and of itself. But I will say special education in plain language has some really helpful guidance to get you started there. But IEEs, right, are by definition conducted by an individual who's not an employee of the school district. So when we talk about them, we're inherently talking about communications with outside personnel. And, I think it's very helpful to look at an IE not as I'm going to find somebody, right, who's going to say everything that I want it to say, but rather, it can be really beneficial to introduce a neutral third party's opinion to the conversation. If the school is saying, I see this issue, and the parents saying, no, this is the issue, or I don't see that at home, or having someone else evaluate the child in a different setting and weigh in can be really helpful. They also might be able to conduct a more in-depth assessment than the school's, typical triennial. I see this particularly if, perhaps a neuropsychological evaluation or something else is ordered. They might just be able to go a little farther than the school's typical evaluations. And these evaluators, if they work with a lot of students, might have exposure to different programs and services and placement options, and might be able to help with that creativity of like, oh, here are some other options that I've seen that maybe haven't been considered yet that we should look into. And so when we're talking about IEs and communication, like anything else, I think it's very helpful to be clear about expectations up front. What's the main issue that we're looking to explore here? Are they going to come and observe in the classroom? They really should. That's super helpful to tie those environments together, but know what you're getting into ahead of time. And again, we've said this several times before, but providing specific recommendations and the reasoning for them. It's one thing to say that, oh, I've noticed that the student benefits from taking breaks. To say, oh, I've noticed that, walking breaks for a couple minutes when the student is in a heightened state are helpful for them to regulate their body and their emotions. And so being able to step out of the classroom and walk for a couple minutes at a time seems to help them calm themselves down. The more information like that they can provide, it's more helpful to the school team to be able to meet together with the family and say, okay, here's, the big picture. And then also considering with your evaluator if they're going to be able to attend a CSE meeting. I think this is great when they can. And I've even seen some evaluators will have in their like cost breakdown say, my evaluation costs X amount of money, and then this includes however many sessions and my attendance at one CSE meeting. And I think that's super helpful to have, you can have the most detailed report in the world, but to be able to ask follow-up questions, and the school might say, oh, well, this is how we do this in our program. Do you think, is that what you're talking about? Could we modify this, and allow people to really brainstorm and communicate together? And then finally, again, if this is a surprise to anyone after our conversation today, but just like everything else, an IEE is to be considered by the district. Doesn't mean they have to implement it. Doesn't mean they have to say, well, this is, more important or weighted higher than the school's evaluations or anything like that. It just means that they should read it. We should talk about it, but it's not a prescription or an order or a mandate that they implement anything in particular. And just a note that, if you do find yourself in due process or do find yourself, at the end of the day in a dispute over this at a hearing, either side can introduce an IE as evidence. So if parents are really like, I've tried absolutely everything else and they won't listen, you can present the IE at a hearing and say, well, here's my evidence that I think this accommodation is really needed or really important. But if, we haven't said it enough times today, like, we really hope it doesn't get to that point, because having conversations and presenting the information to the school and presenting the information to the family and getting everyone on the same page really is the best option. And I'm sure, Shari has some parents she's gotten to know really well over the years, because you've got to remember too, when you're involved in special education, that CSE team is going to be your child's CSE team for years. And I've had parents call in and they're like, okay, well, I need an attorney and I can't talk to the CSE anymore. It has to go through the attorneys all the time. And the answer to that is absolutely not. No matter if you're involved in legal proceedings, no matter if you're having disputes or anything, it's your student's CSE team and it's your district, and that's where your kid goes to school, and you have to be able to have a relationship with those people, and you have to be able to talk with them, and you have to be able to meet and communicate with them, or else it's just not going to work. So I think we reached the end of our slides. I don't know if Shari has anything to elaborate on, or if we have any more questions in the chat, but I'll put down the screen share so we can see more of everything.
Yes, we definitely have questions in the chat. What time does this session end? Is it 10:30?
I believe it's
Yes.
10. Oh,
Okay, nice. So we have some time to take questions. I've got a list of them, so I will jump right into it. The first one kind of goes back to something we've already talked about, so I apologize if this is a repeat. It says, can a parent request to see a videotape regarding your child's behavior?
So I guess, I mean, if a videotape of it exists, they could request if there's one in the file. But I mean, videotapes are complicated, right? Because a lot of schools have cameras in common areas for safety purposes, but it's typically, in my experience, not the practice of schools to be making detailed recordings or holding on to recordings unless there's a specific issue that they've flagged. They're typically not just making and keeping recordings of the entire school day and what all the kids are up to.
Agreed. That's the same thing we see here. We have had parents request to see a video. Usually it comes from like a school bus and a disciplinary action. And if there's a disciplinary action attached to what the child has allegedly done, we do show the video to the parent if they want to see it. But not just randomly, they were walking to the bathroom. You know, we don't go scouring the cameras for that.
And I think, that's important too. If there's an issue, about at the school bus and you want to see a recording, don't wait a month to say, oh, can we have the recording? They're not going to archive and keep that information forever. So if there is a video recording that you're interested in, notify the school and ask them about it right away.
Timely communication.
The next question says, does FERPA cover all records under the control of the school or just the ones that are educational records?
So generally all, excuse me. Pardon me, it's allergy season, everybody. So it covers all educational records, but the definition, right, of what could be considered educational is super broad. So, when we're talking about education, we're talking about their grades and their schedule and their discipline and their everything that's happening and related to and going on at school. So it's kind of hard, I guess, unless someone has a specific type of record. And so I see in the chat, nursing records. So generally, that medical information is also going to be part of the student's file as well. I mean, 1 and 2, right? If you're looking for specific, say, information from the school, not to take the easy way out of the question, but I think knowing whether it's HIPAA or FERPA, which it's usually FERPA in the school context, but knowing, which law applies isn't necessarily as important of saying, this is the information I'm seeking for this person or this purpose, and making sure that you make a request for it. So if you submit a request, right, for, I want to see my child's records. You don't have to write to the school and say, pursuant to FERPA, I want X, Y, and Z. Like, the school knows you're not a lawyer and they're not lawyers either, and they don't need you to be citing to statutes for the information that they want to see. You just need to ask for what information you're looking for.
Rolling right into the next one because I have a long list, so I want to try and get as many of these in as we can. It says, can a school or district restrict access to classroom observation to outside providers due to the privacy of other students?
So there's
Let's talk
I
about
have
what they can do and what they should do.
Yeah, so they're not, you have, the outside provider, right, has a right to have the observation of the student. An observation in the classroom, you know, it's not going to be accurate or right or appropriate if they're like, okay, to observe your child in school, we're going to put them out of their classroom and in a room all by themselves with no one else there. You know, that's not required. And so the school, I would be concerned if they said, no, there are, your child is in a classroom of more than one student, we're not allowing a provider to come in. You know, that being said, it's always helpful for the class and the students to talk about, you know, when are we going to do the observation at a time that's going to be the least disruptive, and how are we going to make it most effective so that we're not interfering with the other students or interfering with the lesson plans. You know, the idea of an observation is we're going to be a fly on the wall and as unobtrusive as possible, so I can just get a picture as an evaluator of what the classroom looks like. There's a specific case citation that I'll have to pull up that talks about observations more specifically, though.
And let me be cynical for a minute. The way that that was worded in the chat is exactly what I hear administrators, building administrators maybe, or even teachers say to a parent when they say, I want to have my outside psychologist come in and look. They don't want them to come in. They don't want them to see what's happening. There's the cynical part of me. And I try to run interference on that. So if you're a parent in that situation or an outside provider, you might want to talk to the PPS director or, you know, the special ed director or something, because we know that that's not an okay thing to say. There may be some communication coming from a building level administrator or a teacher that they don't have that knowledge.
And I found the specific, if you need something to reference, I will put that section in the chat.
Thanks, Alyssa and Shari. Next question. It says, is it necessary for school districts to ask parents for a specific reason why an IEE is requested? And what did you, I'm going to start over. Is it necessary for school districts to ask parents for specific reason why an IEE is requested / what you did not agree with the district evaluation in order to proceed with an IEE?
So if I'm understanding the question correctly, I think the answer is no, but. So you can request an IEE, and it's because you disagree with the district's evaluation. And so, you know, it's helpful to say what you're requesting. If they had an OT evaluation and a psychoeducational evaluation and a speech, you know, if there's a type, say, you know, this is the particular evaluation, and you're not required to give a reason or what specifically you disagree with. The school can ask. But just keep in mind that if you get to the point where the school says, no, our evaluation was great, we stand by it, it's completely accurate and thorough, we're not granting an IEE. If you're going to get to the point where you have to dispute that, you're going to want to, for your own purposes, have a specific reason as to why you disagree. And I don't trust it because the school did it and everyone there is biased, or, I just don't like it, is not an acceptable reason. You have to be able to look into, the scope or the content of evaluation and come up with something, not come up with something, but, be able to present something specific. But again, I'd plug for special ed and plain language here. I'll try and pull up a link to that to stick in the chat as well.
I put it in the chat. I'll post it again.
Perfect.
All right. Next question. How do you get a hearing? Which I'm guessing, how do you request a hearing? How do you start that process?
You try not to, but I always suggest to parents that we could go to mediation first. I've gone to mediation 3 times in my 12 or 13 years in this role, and it has not resulted in a hearing. Each time we've gone to mediation and have been successful. So I would always suggest that first. But Alyssa, if a parent says, nope, I want a hearing.
Yeah, if you get to that point, you have to file a complaint. And if you go on to the Special Education Plain Language has information on this as well. It's my favorite book, guys. Check it out. But the New York State Education Department website also has a lot of good and a lot of do-it-yourself information about how to do that.
Next question. Can you mention communication tips as it relates to transition planning for when a student is exiting school? Yeah,
so if get everyone involved if you can, particularly if your student is already connected to outside agencies. So I know we see some folks, right, who maybe are already working with OPWDD or OMH. Keep in mind that anyone with information about the student and their needs can be invited to a CSE meeting. So if you're having that annual review, the student's a teenager and they have a service coordinator, they're working with Access VR, or they have to invite them to the CSE meeting. Get everyone who's in the picture involved and seated around that table or in that Zoom room to talk.
A lot of our districts, mine included, have a transition coordinator or someone who acts as the role of transition coordinator. And our folks start meeting with parents and students and OPWD or Access in 11th grade if there hasn't been any movement. I have some kids that have gotten OPWDD access in 3rd grade, and we continue to work with them. So always ask your district if they have a transition coordinator. And if they say they don't, then you can ask them if they could suggest someone. And I know that there's a lot of people on this call that can act as that. I see a lot of names that I recognize from different agencies and can act as a transition coordinator. There is some stuff to navigate when filling out the applications for Access and for OPWDD. And earlier is better. The sooner you get it, the better.
Next question says, can you point us towards information we can share with parents about the role of the school board? There is a growing movement pressurizing and blaming board members. To me, this is a major communication issue.
I mean, from my perspective, we always look at it as the school district Board of Education makes policy. And that's where their role, if you will, should stop. We're hired as administrators and the superintendent and, to implement the policy and manage the district. But as a Board of Education, they make the policy. We try not to have them micromanaging what's happening in the district so that they don't get into that situation. But I'm not sure if that's what the question is asking.
Yeah, and I think if I'm perhaps imputing a little extra context into this, but some might be helpful to explain to parents, who have concerns, what comes from there's right a hierarchy of there's the school board, but then there are also the state education department, and other information and regulations that come down, beyond the district's control entirely. And so, but I've seen a lot of school districts who have really informative school board websites as well that talk about, here's our school board, here's what they do, here's how they work, here's how you can go to the meetings, that have a lot of good information on them.
That's what I was going to suggest. I'm looking around on the back end, and a lot of the websites have very well written explanations of what they do. So that might clear up some confusion. Okay, we got a little more time. So another question we have is, we've had concerns in the past about parents granting permission for school personnel to talk with outside providers. We have had outside providers feel pressured by the school staff to take their perspective, and it has upset and frustrated the outside provider and the parents. Effective communication is key. Is there any want to place controls on the communication between schools and outside providers? And can parents be included in the call and communication?
So that depends on what, you're giving consent to. I see where you could write, specify your consent with an outside provider that says, you can talk to this therapist or this doctor if I am also present on the call. But I'll just caution, too, that it works both ways. And so, and it's absolutely a valid experience that some parents have, are like, oh, the district's trying to get, all the outside providers on board. But then there are also equally valid situations where the district's like, oh, this person outside the district is just trying, doing whatever the parent says. And so I think it's important to recognize that biases can run both ways. And yeah.
Go into the situation with choosing sides like that, then you're going into it as someone's going to win and someone's going to lose. And that's not that's not, in my experience, a good way to have these discussions and to get, good information that you can use within the school district, within the student's school day. So you have to go in there, whether you're a school district personnel, an outside provider, or a parent, with a mindset that I'm going to actively listen to what these folks have to say. And I might find something, even though I'm mad about it, that they've gone and done this, I might find something that will be useful to the student. You've got to go in with that kind of mindset, I guess.
Yeah, the purpose of communicating with outside providers, right, is not to say like which, parent or school, who can build up the most people on their side, on their team. Everyone is on the same team theoretically, right? And it's the team of what does the student need and what's going to make them succeed best in school. So pitting sides against each other, or recruiting folks to support your position is not a helpful approach at all.
Okay, I've got one last question for us, and then I think we'll be good. It says, if a student is having an acute mental, emotional, behavioral health crisis, can the school insist that the student undergoes a mental health evaluation before allowing the student to come back to school?
I'm gonna ask Alyssa to answer that legally, because I know that we've insisted and parents have done that. We do it because we feel like it's the best thing for the kid, but I'm not sure that it's a legality thing that we can do without admitting the student back to school. I don't know.
Yeah, and I mean, to be perfectly honest with you, I work primarily not with individuals who have mental health needs, so I don't know the answer to that question off the top of my head. But I think that if you are finding yourself in that situation, and anyone is trying to exclude your student from school or place conditions upon their return to school, there are a lot of laws and restrictions in that area. So if you find yourself in that situation, I really think that you should talk to somebody about it sooner rather than later.
I do see we still have a couple minutes left, and I did get one more question. Someone did ask for a clear list and explanation of the process and steps for getting an IEE, IEP, and 504 plans. I directed them to the special education and plain language booklet. It really is fantastic. It's a great place to start, and I know it has all its stuff listed out in it. And I linked to it again in the chat. And then the other question that we received says, at what point do the school districts recognize the benefit of and seek out the options for community agencies to provide transitional supports and services, particularly for students who are deaf and hard of hearing?
At what point is closed? I mean, it really depends on your district, I think, and what their experience is and their connections to other agencies in the area. I think if you already have someone you're working with outside of school, it's helpful to get them involved sooner rather than later to be having those conversations. But if you're looking for services in the area and aren't already connected to an outside agency, definitely ask your district about it. And if they don't know anyone, ask them to find someone to help you seek that out.
Yeah, I have a few students that are deaf and hard of hearing, and I have a few with visual impairments. And those are two very isolated fields, and there are more specific agencies that deal with those disabilities in particular. So there might be, I don't know, a case manager or Medicaid coordinator or something that you're working with that would have better knowledge of that even than your school district. Because I don't have a lot of knowledge of what's out there. For deaf and hard of hearing, I have a hearing impaired specialist here in the district, so she's my go-to for that. We don't have any TVIs that work directly for our district. We have ones that contract through BOCES, so we kind of just learn as we go. So I don't know, that's very specific though.
There's a question in the chat that says, is there a best way to find agencies in the area to connect families with? I would always recommend, if you have a local independent living center, they normally have lists of the local resources in the area. I know I work at DRNY. I know that we have resource hubs. I'm sure Parent to Parent also has resource hubs.